Good day guys, I'm Michelle Daroy from BSBA13. I'm going to report about the law of partnership starting at the article of 1784 up to 1786. So let me start at the article 1784. It is stated here that the partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. So a partnership is a consensual contract. Hence, it exists from the moment of the celebration of the contract of the partners. Meaning, it is stated as consensual. This will bring form into consent. So as long as the pertaining requisites are present in the contract. For example, you have an opposite sex relationship with someone, then you've shown interest and court the girl. When the girl said yes to the proposal from the boy, officially they are now dating, which the girl gave consent to the guy, so there is a relationship developed. But the question is there pertaining requisites present? So kinahanglan, sure good ka nga na kay feelings, no? Because there are always a requisite kung sa ato pa na siya mga requirements. What are the requisites when you are dating or seeing someone or having an intimate relationship with someone? In our words, it is regulation. In the law, it is a requisites. Here, the requisite should be they both love each other because the relationship won't work without love. Same as you're going to into a partnership or partnering in a business aspect of the business. So the business won't run smoothly if there is no trust, harmony, and respects. Another one, when was the dating started? Is it when the moment the guy courted the girl? Answer, it is when the time the girl gave consent to the guy. So, ang guy di gina mag-assume, no? So, it should be, lagi na siya yung mga certain requisite. Tanan na itong law na ay certain requisite. Huwag kang assuming, guy. Article 1785, when a contract of a fixed term or particular undertaking is continued after the termination of such term or particular undertaking without any express agreement, the rights and the duties of the partner remains the same as they were at such termination. So as far as is consistent with the partnership at will, a continuation of the business by the partners or such of them as had habitually acted therein during the term, without any settlement or liquidation of the partnership affairs, is prima facie evidence of a continuation of the partnership. Partnership at will is one in which no term of existence has been fixed and which may be terminated at the will of any partners. So based on my research and reading, this is a kind of partnership that it has a partnership with a fixed term. The simple meaning is a form for a definite period of time. In other words, there is a specific date expiry for the partnership. So example, there is a certain event for a known Korean group Blackpink here at the Philippines and you decided to have a small corner business knack with your friends. So the partners will exist only for the said concert event. After the event, the partnership will be dissolved here and then. So here is the question. What if the business continues or the customers continue patronage the said business? Answer, this is the time that the partnership deemed as a partnership at will. Meaning it is a form of business partnership where there is no certain duration of the business term of the partnership. In other words, it is completely open-ended business. So anytime you can just dissolve the partnership in order for you to have a fixed term partnership. In Article 1786, every partner is a debtor of the partnership for whatever he may be promised to contribute thereto. He shall also be bound for warranty in case of eviction with regard to specific and determinate things which he may have contributed to the partnership. In the same cases, and in the same manner, as the vendor is bound with respect to the vendee, he shall also be liable for the fruits thereof from the time they should have been delivered without the need of any demand. So what are those obligations for partners to contribute? 1. Shall deliver at the beginning of the partners, or if a different date has been agreed upon at the stipulated time, the partners or the properties he agreed to contribute. 2. Shall answer for eviction in case the partnership is deprived of the ownership of any specific property he contributed. Number 3. Shall answer to the partnership for the fruits of the properties whose delivery he delayed from the date he should have contributed it. The actual delivery without necessity of any demand. Shall preserve said properties with the diligence of a good father of a family pending their delivery to the partnership. example, when you are into a business and in a partnership form and you promise to contribute a building for your laundry business, the wash up laundromat, you've both agreed for that, and the date that you promised is in October 25, 2020, but you failed to comply the said agreement, you are automatically become a debtor of the partnership, even if the absence of the demand. So in other words, you should keep your promise. Once you said it, you have to mean it. Huwag kang paasa. Thanks. That's it, guys. Hope you've learned something from my report. Thank you, and God bless you all.
Article 1787. When the capital or part of thereof which the partner is the bound to contribute consists of the goods, their appraisal must be made in the manners of prescribed in the contract of the partnership, and the absence of stipulation, it shall be made by expert chosen by the partners, and according to current price, subsequent changes thereof being for the account of the partnership. Appraisal of goods of property contribute. Number 1. The appraisal of the value of goods contribute is necessary to determine how much has been contributed by the partners. In the absence on the stipulation of share of its partners in the profits and losses, in the promotion to what he may have to contributed. For this profit, it's the beginning to capital its partner. At the year of that information, the partnership, kung wala agreement na nangyari about share of ratio, profit and loss, ito nalabas ang contribute capital or beginning capital. Next is, after the goods have contributed, the partners shareholders and the rest of the gets the benefits of subsequent changes in their value. Since kung karoon na ng transfer sa ownership, ang mayari sa asset and sa goods ay sa partnership, kung may changes mang mangyari, ito ay ma-account sa partnership na may benefits man o risk. Article 1788. A partner who has undertaken to contribute a sum money and fails to do so becomes a debtor for the interest and damage from the time he should be have complied with his obligation. The sum rule applies to many amount he have take from the partnership coffers, and his liability shall begin from the time he converted the amount to his own use. Obligation with respect to contribution of money and money converted to personal use. Number 1. To contribute on the date due the amount he has been undertaken to contribute the partnership. Kung para sa ilang date na ilang gisabutan, dihar aniyang gihatag ang contribution. Number 2. The reimburse of amount he have taken from partnership coffers and converted to his own use. Kay nangutang man siya kay partnership, dapat niya bayaran. Number 3. To pay agreed of legal interest, it falls to pay his contribution on time only in case he take amount from the common fund and converts in to his own use. Kailangan ni partnership ibigay ang contribution, pero dili niya mabigay ang kanyang contribution specific date because of that accurate ng interest for being delayed for the lost values agreed or legal interest. Number 4. Identity the partnership for the damage caused to it by the delay of the contribution of the conversion of any sum for his personal benefits. Kung may damage nangyari dahil sa delay, is partners liable that damage other than that partners also to pay legally interest.
Hi, my name is Camille Cañon, and I I am going to discuss about Articles 1789 and 1780. Article 1789 said that an industrial partner cannot engage in any business for himself unless the partnership expressly permits him to do so. And if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision, with the right to damages in either case. Remember, industrial partner are those who offering their expertise, knowledge, skills to a company as an investment to a business instead of money, while capitalist partner are those people who invested money. An industrial partner cannot engage in business for himself, meaning dapat yung full attention mo ay nasa current partnership lamang. So dapat po na maging faithful po tayo at huwag nang maghanap ng iba. Kidding aside, put in mind that you only invested your services or labor like what I mentioned earlier, skills, knowledge, expertise, and other more. Unless may permiso ka galing sa business partner mo na mag-venture ka into other business. Pero, pag matigas talaga ang ulo mo at nag-open ka pa rin ng ibang business, your capitalist partner have the rights to kick you out of the partnership. Or, mananatili ka pa rin sa business pero ang capitalist partner mo ay maaaring kunin ang mga kinita mo sa bagong mong business. Yes po, pwede pong mag-demand si capitalist niyan. Because again, your focus and your faithfulness are supposedly in that current partnership lang. Dapat yun guys, focus at sa usa. Or in either case, worst scenario, the capitalist partner have the rights to file a legal action for damages laban kay industrial partner because obviously, may nilabag kang agreement. So to put it in a simple way, don't open or venture to other business if you are currently in a partnership. Industrial partner barred from engaging in business to prevent any conflict of interest between the industrial and the partnership and to ensure faithful compliance by said partner with his prestation. O sa madaling salita, pinagbabawalan ang industrial partner na mag-open o sumali ng ibang negosyo. And that is Article 1789. Article 1790 said, unless there is a stipulation to the contrary, the partner shall contribute equal shares to the capital of the partnership. Meaning, if kahit na hindi natin alam ang value na shinare ni industrial partner, meron po kayong stipulation o agreement that both parties should have equal shares or contribution to the capital of the partnership. Ang artikulong ito ay naninigurado lang na may fairness o equal shares at hindi magiging unfair sa iba mong business partner. And that is the purpose of Article 1790.
This is Hannah Rose and I am going to report or to discuss the Article 1791 and Article 1792. So, Article 1791 talks about if there is no agreement to the contrary, in case of an eminent loss of the business of the partnership, any partners who refuses to contribute an additional share to the capital except an industrial partner to save the venture shall be obliged to sell his interest to other partners. So for example, if there is one capitalist partner that is hard to contribute, those partners that were always bubbling or choosy, they will force to sell his interest to the other partners. Why? Because he refused to that contribution. He refused the partnership. You're already there to save the business, but these capitalist partners declined the partnership. He refused. So by doing that action, by refusing to give additional contribution or contributed capital to the partnership, it shows that there is a lack of interest. So there is a lack of interest in doing his part to the business. So where he is able to join the capital, where he is able to give capital, but he refuses to do so. So it means there is lack of interest. So might as well remove that capitalist partner from the partnership. Because in the Article 1791, partners or capitalists must contribute additional capital in case of eminent loss to the business of the partnership and there is no stipulation. Otherwise, refusal to do so shall create an obligation on his part to sell his interest to the other partner. So in the scenario, the capitalist will force, he or she will force to sell his interest to the other partners. So that is Article 1791 talks about. So next is the Article 1792. So Article 1792, if a partner authorized to manage collects a demandable sum which was owed to him in his own name from a person who owned the partnership, another sum also demandable. So the sum thus collected shall be applied to the two credits in proportion to their amounts. Even though he may given a receipt for his own credit, but he have given it for the account of the partnership credit, the amount shall be fully applied to the latter. So, for example, there is a debtor. The debtor lended money to managing partner and to partnership. So, managing partner is the authorized partner based on Article 1792, stated above. Then partnership has a separate personality that can be lended easily. So the debtor decided to pay first his balance or his debt to managing partner. So he gave the money to the managing partner, then the managing partner received the exact amount from the debtor. So it is a receipt of managing partner in the Article 1792. So in this scenario, when debtor paying first his debt on credit to managing partner is required. He is required to apply the sum collected to two credits in proportion to their amount. So it means that not all debtor's payment will be received by managing partner. Let's put it in a clear situation. For example, 100,000 will be the exact amount that debtor paying to managing partner. So in proportion into the amounts, they will divide it into two categories. So they will share the equal amount to partnership. So for example, 100,000 divided by 2 equals 50,000. So 50,000 for the partnership and 50,000 for the managing partner. So that is in the first scenario. They will share the exact amount where the debtor is paying to managing partner. So managing partner share to partnership. That was in the first scenario. So in the second scenario, if a debtor paying debt to partnership, so kay partnership na punta, kagani naman is ka managing partner. So if a debtor paying debt to partnership, then he received the amount of partnership. The whole amount or the whole sum shall be applied to partnership credit. So nothing goes to the managing partner. So partnership owes it all. So all the exact amount of 100,000 will be owned by partnership. So in this case, all you have to watch or all you have to get the attention is where the debtor pays or credits his debt. So that is the Article 1792. So in the second paragraph of Article 1792, it states there that the provision of this article are understood to be without prejudice to the debt right granted of the debtor by Article 1252, but only if the personal credit of the partner should be more onerous to him. So for example, if a debtor has a multiple debts to people or to the citizen, then he has the right to decide where or who he will pay first. So basically, it talks about the application of payment. So it says that the debtor's application for payment will be no longer prejudice who he will pay first. It his choice who he will prioritize. If he will prioritize those people who are more onerous to him or more beneficial to him. So that is the Article 1792 talks about.
This is Ronel Aque. Allow me to discuss the Article 1793. A partner who has received, in whole or in part, his share of the partnership credit when the other partners have not collected theirs shall be obliged. If the debtor should thereafter insolvent to bring the partnership capital what he received even though he have given receipt or share only. Case under this article is different from the Article 1792, which treat of two distinct credit. One is in favor to the partner, and another is in favor to the managing partnership. When it comes of this Article 1793, there is only one debt, but two or more debtors decided to pay his debt and the partnership credit. The partnership being a co-owners of the partnership, they have right over the debt paid because they have a share. For example, A and B are partners and C owes the capital, a sum of 20,000 pesos. B is managing partners, but A is collect his share in the 20,000 pesos and C pays 10,000 to which issues receipt in his name. When B's turn to collect, C is ready insolvent. Unsay ang ngayon buhaton ni A? A should return his 10,000 to the partnership and split it, which B and C has already insolvent or unable to pay debts owed. What is meant to be insolvent? A person is insolvent when his liabilities exceed his or her asset. Requisites of application of this article are the following. A partner has received in whole or in part his share of the partnership credit. Number 2, the other partners have not collected their shares. And number 3, the partnership debtors has become insolvent. Take note that however collected doesn't matter as it doesn't make difference. If you share early and the other partners cannot yet, there's because the debtors has become insolvent, then you must return your shares into the partnership so that no one get more they should have.
Mydian S. Pacamalan, Article 1794. Every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the court may equitably lessen this responsibility if through the partner's extraordinary and useful profits have been realized. It is mean, every rule there's an exemption. If unusual profit derived from extraordinary effort of the partner at fault, the court may lessen the partner's responsibility. Take note of the word lessen. Still, it cannot be compensated. For example, partner A, his obligation or duty to the partnership is to make a sale, but he caused damages to the partnership. On this sale contract, he confront damages to the partnership because of the mistake. Partner A will be liable because of his fault, but because of that unusual profit, he brings through extraordinary effort and to the other activity. In this case, based on the rule and integrity, he mitigates liability for damages. Partner liable for damages caused to the partnership. Article 1794 follows the general rule of contract that where a person is at fault in the fulfillment of his obligation, he shall be liable for the payment of damages. The partner faults, however, must be determined in accordance with the circumstances of persons, time, and place. Liquidation necessary to certain damages. It is first necessary that a liquidation of the business thereof be made to the end that the profits and losses may be known, and the causes of the latter and responsibility of the defendant, as well as the damages which its partner may have suffered, may be determined. Example, a partnership between Lynn and Joy is engaged in an auto shop business. A customer bought a car to be painted yellow, but Lynn bought red paint instead, and the car is painted red. Damages are suffered by the partnership due to the repainting.